Right. A very good afternoon, ladies and gentlemen, wherever you are catching us from. I hope you're all having a very lovely afternoon today. I know you've all kept your time, so we want to say karibu sana. Thank you, bienvenue. For those watching us from the Francophone, it's really amazing to host you once again for our East Africa Law Society webinar session. And today in particular, we are having a very interesting subject on dispute resolution. We do have our panelists online, so I'm going to encourage you to tell a friend that we are starting our webinar soon. So if you haven't logged on, let's give it about a minute for those who are trying to log on to come in and settle in, and then we'll start it from there. I'll be back shortly to introduce our moderator. All right, ladies and gentlemen, it is 5 minutes past the hour of 2. Good afternoon once again for those who are joining us for this very special session that is going to discuss international arbitration. And today we are going to navigate the recent global developments in international arbitration and discuss the current trends that are affecting this field of practice. Now, this afternoon, we are honored to have Miss Eunice Lomalas. Miss Eunice Lomalas is a trial advocate and a practicing a trial advocate, a practicing arbitrator, and a mediator accredited by the Mediation Accreditation Center, MAC, and an international arbitrator fellow and a mediator. She's Kenya's representative at the International Center for Settlement of International Disputes in Washington, D.C. She's a member of Public-Private Partnerships Petitions Committee and the Advocates Disciplinary Committee of the Law Society of Kenya. She's listed in the Kigali International Arbitration Panel, the Nairobi Center for International Arbitration, and listed in the Neutrals Panel or of the Delos Arbitrator Database in Paris, the Mauritius Arbitration Mediation Center, the Lagos Court of Arbitration. She's the advocate of the High Court, tutor, and a trainer accredited by the Chartered Institute of Arbitrators, London, a qualified patent agent, a commissioner for oaths and notary public, and founding member, chairperson of Women in Alternative Dispute Resolution. She's recognized for legal excellence and contribution in the ADR space by the Law Society of Kenya, and she is a proud member of our Dispute Resolution Committee and a friend of the East Africa Law Society. She loves arbitration. She talks arbitration. She lives arbitration. Ladies and gentlemen, let's welcome our moderator, Miss Eunice Lumalas. Eunice, we are all yours for the next 2 hours. So take us away now.
Thank you very much, Gabriel. And thank you for the fantastic work you're all doing at the East Africa Law Society, for inviting me and the great team of panelists this afternoon. And so, ladies and gentlemen, you are also thanked for making time. Welcome to this session. We will be navigating recent developments internationally and current trends in international arbitration. As you all may or may not know, when we talk about international arbitration, we are looking at three main things. We are looking at, number one, international commercial trade. We are looking at contracts between states and states, for example, Uganda and Kenya agreement, therefore an arbitration between states. And thirdly, we're also looking at a dispute or disputes and arbitrations between investors and states. So that's normally called investor-state arbitration. So those are the three main aspects of international arbitration. And there have been recent global development and trends, which this afternoon we will have four distinguished practitioners take us through and help us navigate. So the first practitioner we have is none other than Mr. Laston Gulume. I trust a lot of us will meet Laston later this year when we attend the East Africa Law Society conference in Uganda. And I hope Mr. Laston will be happy to receive all of us. He is an advocate of the High Court and has practiced extensively at the East Africa Court of Justice. I hope you're bringing more and more arbitration into that court. He is a partner and director at ALP Advocates in Kampala, and a passionate instructor and lecturer at the Ugandan Christian University. So his main area is dispute resolution, as you can see. He also looks at cross-border practice, trade and investment law, IP and commercial law practice. He has a Master's of Law degree from South Wales University, UK. I think this all is part of us trying to see who are the people ahead of us. Bachelor of Laws from Uganda Christian University, and his full CV can be found in his social media. So look up Laston Gulume and find out more about him. Second, we have Françoise. Hope I got that right. I'm also learning French. Ingabire. She is a lawyer. I hope we can see her. There she is. She's a lawyer, chartered arbitrator, and a mediator also, qualified from the Cape Town University in South Africa. She's a member of the Association of Young Arbitrators, African Arbitration Association. We are proud of our association, and has worked as tribunal secretary. She'll tell us what tribunal secretary is. I hope we'll hear more about it when you look at opportunities for our people in East Africa in tribunals. And she has, for the past 5 years, been working at Kigali International Arbitration Center, where she co-administers KIAC arbitrations and mediations, and has done so for over 200 cases. So that's quite remarkable. She has also participated in appointing tribunals, and she'll be telling us why she hasn't appointed some of us in a number of years now, and advising tribunals, sharing best practices with the parties in complex legal issues arising out of arbitration. She has attended various conferences, and as you'll know, in international arbitration, it really pays if you can attend conferences and interact with colleagues, and that way you get to meet like Françoise, and she'll appoint you as arbitrator. So she has been at SOA's conference, IBA as a speaker, among others. Thank you very much. We look forward to listening to you. We also have none other than Collins Gatete, whom I had initially asked if he's a Kenyan, because that name Gatete is very familiar. Maybe we can see him. So Collins runs a practice in Kigali, and it's a renowned practice, Collin and Collin Legal Solutions. So all the legal solutions. And he is a holder of a master's degree in international commercial and arbitration law from Stockholm University, Sweden, and a bachelor's degree from Catholic University of East Africa, Nairobi, Kenya. So basically, when you look at his CV, he has undergone extensive training in commercial transactions, among others at ALSF, which is the African Legal Support Facility. Look it up kindly, because they always have these trainings and sponsorships that they offer to Africans to study arbitration, investment law, arbitration, among others. And he possesses a certificate in International Law Principles Academy in Germany. His prior professional experience involves working at Rukangira Law Chambers, the African Legal Network, LM Solutions, and the National Public Prosecution Authority in Rwanda, plus the Bank of Kigali. So his responsibilities from the different areas of expertise that he has have encompassed reaching and preparing legal documents, such as pleadings, motions, briefs, and representing clients in proceedings in arbitration. He's also stood out as a good negotiator and has been pointed out as a leading negotiator in various settlements. He's a lecturer at the School of Law, University of Kigali, and has spoken in various panels. So welcome very much, Collins Gatete. We are all here and willing and ready to learn from you. Finally, our final speaker is none other than Ida Juma, who is a managing partner at Rubea and Company Advocates, and has 14 years of experience in basically the financial services sector and arbitration. I can vouch for that because I have interacted with her in that field in arbitration, even here in Nairobi. Her experience extends to representing diverse clientele, investors, financial institutions, hedge funds, and so basically she's been in dispute resolution relating to finances, and it's good to stand out in a given area. Like now, she's our financial expert, and she's stood out as specialized in that area. In fact, Ida is actually referred to as and has been acknowledged as the woman leader in Burundi by the IFLR 1000. You need to look that up at her personal profile. So she has a track record which speaks for itself. And beyond her work, she's also a person that contributes to the legal community in different ways. She has served as a member of the Bar Council of Bujumbura and serves as a member of the board of directors of Burundi Capital Markets Authority, member of Association of Young Arbitrators, and chairperson of ELS Arbitration Committee. So that's quite outstanding. Ida frequently shares her expertise as a sought-after speaker in various financial services and arbitration topics. I have met her and I can attest to that before. Ida, welcome. Greetings from Kenya, and yeah, we're ready for you. So as I start off the discussion, I will allow our speakers to share in 15 minutes each. And I would like us to start with Mr. Laston Glume. You just speak to our audience for 15 minutes about your topic for the day. And which is
Thank you.
emerging trends, sorry, which is emerging trends in international arbitration and the implications in practice. Welcome, last one.
Wow, thank you so much, Eunice, for those very kind introductions. I'm sharing my screen. I hope you're able to see my shared screen from your side.
Yes, I confirm we can see your screen.
Okay, very well, very well. So I just add my voice to yours as we welcome our participants for joining. I see quite a number of people have joined online. You're most welcome. What I want to just engage us to spark off this very interesting discussion on the emerging trends in emerging trends in international arbitration and its implication on the legal practice. I love how you've set the stage, Eunice, by giving us a good score that when it comes to international arbitration, you are really talking about international commercial trade. You're talking about the disputes between states, state to state, and then also disputes between investors and state and how those are resolved. And in my presentation, really, I'll just focus on three things since we have, we want to mostly engage the audience in the chat and the Q&A and what we are picking from this discussion. I'll give a bit of a precursor on international arbitration, basically what it is, what it offers, and a key framework, something that I see some of the practitioners who have joined online who have very key interest in international arbitration. I see some of them, I'm familiar with them, are quite familiar with this framework. So I will not belabor it, but just give a short introduction about it. Then we'll delve into the emerging trends. What are they? What is happening in the landscape of international arbitration? And we'll also conclude by the implications that have come or that have been observed in as far as legal practice is concerned. Friends, if you're an advisor, a legal advisor, a dispute resolution attorney, you practice from a particular jurisdiction, but our clientele comes from across the globe, and we are in what we know as a global village. So let's begin here. I found this quote by Samuel Gompers, who was the president of the American Federation of Labor way back before, I believe, all these generations started, Generation Z and born before computer generations and so forth, in 1888, between 1888 and 1924. This is what he said, and he's quoted to have said, when he was asked, do you believe in arbitration? He was asking this and say, yeah, I do. But he said that, but not in the arbitration between the lion and the lamb, in which the lamb is in the morning found inside of the lion. What did I pick from this quotation, and why do I find it interesting? When it comes to international arbitration, because of the changing landscape, because of the things that influence that practice, if you walk into that arbitration process and you're not prepared, you don't know the trends, you don't know what is influencing or what are the hot issues around these arbitrating international disputes, then you may end up being the lamb in that scenario. So I just want to add my voice to Eunice to say thank you to ELS for putting this together, because it helps us sharpen ourselves as practitioners and also share knowledge that you walk into any of this advisory or any of these arbitration processes when you have some good chips up your sleeve that you can use to make you an efficient advisor. But to delve into what international arbitration basically is really, you are looking at a process which is private and consensual, where the parties consent to this binding method of resolving disputes between the parties. Eunice gave us an example or the scope of the kinds of parties that are involved in such international arbitration disputes. And usually you may find that these parties are coming from different countries, and she already talked about companies and individuals involved, but also the state-to-state disputes. So it is an alternative, it's an alternative mode of resolution of disputes to the traditional court litigation, and it offers several benefits. And this is what I want to highlight, just so we are sure. And later, some of my colleagues will be taking you through the different institutions, and will also be adding to the discussion of some of the things that I may not be able to cover in this introduction. So the benefits, of course, you'll find something that is always fronted when it comes to arbitration generally, but more so in international arbitration. When you talk about neutrality, there is a way parties feel that the grounds are leveled when you're not being subjected to a domestic jurisdiction where a particular party may be more of a stronghold and have more connections. So neutrality here, you're looking at a dispute which is submitted to be resolved by a private, neutral set of arbitrators or an arbitrator, rather than the courts of one of the parties' jurisdiction where they are domiciled. What does that mean? We know as practitioners that when a particular party is domiciled in a particular jurisdiction, they will have the home advantage. So the neutrality here is where the parties submit a particular dispute. Usually they can be complex commercial disputes, and they believe that the party who is adjudicating or arbitrating that dispute will remain neutral. And also the other advantage is the flexibility. You see, parties have the flexibility to choose who is going to be the arbitrator over their dispute. And of course, without opening the discussion on the basics on how the arbitrator is selected, and later we'll a bit highlight on the arbitration agreement and how it shapes that framework when it comes to arbitration, the rules, the language, the seat of the arbitration, so that the parties have that flexibility. When it comes to the ordinary litigation, whoever judge you find, wherever the court is located, that's where you have to go. That's who has to attend to you. The other advantage is the enforceability. We are talking about international disputes. You're talking about disputes that have an implication of crossing borders. When it comes to enforcing of what we call foreign judgments, when it comes to our jurisdictions, you find that arbitral awards enjoy a more reception on enforceability because they are backed by treaties. They are backed by international agreements. An example here, I've listed the example of the New York Convention, where you have over 150 countries that have ratified this convention. It's the Convention on the Recognition and Enforcement of Foreign Arbitral Awards. And then the ICID Convention, when Eunice was talking about the state investor disputes. We usually refer to the convention, the settlement of investment disputes between states and nationals of other states. So there is the enforceability advantage that a foreign award, an international award, an award that has been rendered by an adjudication body which is not domiciled in a particular jurisdiction would be more receptive for enforceability under the framework of those conventions. Then the privacy, of course, that arbitration, unlike court, arbitration is private and confidential, unlike court proceedings, which are generally public. Now, the framework, just still on the introduction, when it comes to the key framework, when it comes to arbitration, you'll know or will just be reminded that this is premised on what you call the arbitration agreement, whether it's a standalone agreement or whether it's a clause within the main agreement under which the dispute or the transaction is arising. And the arbitration agreement is key because it determines many things. It determines the scope of the dispute. It will also have in there the determination. A good arbitration agreement will have the determination of the seat of the arbitration. The seat here of the arbitration, of course, is what determines the procedural law that will apply and the practical aspects of the arbitration. For example, when you talk about the supervising and supporting of the arbitration, interim remedies you're running to get maybe from a particular court, and then the seat determines the legal jurisdiction governing the arbitration proceedings. And also, you will have a venue. Still, the arbitration agreement, a good one, should provide for a venue. The venue is the geographical location where the arbitration will be conducted. Closing on the key framework, of course, there is the issue of the governing law of the arbitration agreement. You could be drawing a contract, you're drawing it under a particular law of a particular jurisdiction, but the parties have the liberty under the arbitration clause of the arbitration agreement to agree and specify on the law that will be governing the arbitration to avoid disputes. And the peripheral decisions, of course, exist where there are such lacunas. The trends are that you don't want to leave such things hanging now that we know what arbitration is and what informs the way arbitration is done. The choice of the Arbitration Institute. or the Arbitral Institute. I am happy that one of my fellow panelists is going to be taking us through those institutes. And what you will be finding there is that the institution that you're choosing will also guide you on the appropriate procedure rules. And if you understand the appropriate procedure rules, you'll choose one arbitral institute over the other because it would favor you if a dispute arises and it has to be submitted to arbitration. Then choosing the arbitrators, the number, how many of them will be. Is it going to be a panel? Is it a sole arbitrator? And of course, this depends. The trend is that the nature of the possible dispute, the complexity of the possible disputes, and then the value of the potential disputes usually now will inform the parties on whether you're looking at a sole arbitrator or you're looking at a panel of arbitrators, and where are you going to be taking this arbitration. Now let's delve into the emerging trends. What are the trends? What you'll find when you just really follow the literature, follow the events, follow the webinars, follow the conferences that are happening in international arbitration, technology, ESG, third-party funding, impartiality, enforcement, and regional trends seem to be among others. These seem to be very, very outstanding in informing the landscape when it comes to international arbitration. Now, when it comes to what the world is experiencing, the technology, the development of technology, the increased use of technology has become and continues to be a very key trend in arbitration, among other fields. Here you're thinking of virtual hearings, electronic document management. You're even thinking of online dispute resolution platforms that have been designed to help parties or have parties resolve their disputes in the most effective way. We cannot forget to talk about artificial intelligence, AI. It's being explored when it comes to document reviews, legal research. And since you're talking international arbitration, these are tools that are helping practitioners look at a wider spectrum of resources, not just within their jurisdiction alone. Things like blockchain, virtual reality, and advanced video conferencing integration in international arbitral proceedings have seen technology, increased use of technology, be one of the key trending elements in international arbitration. Then the focus on environmental, social, and governance disputes. Of course, here you'll find that there are a growing number of disputes that are related to climate change, human rights, and corporate governance. The companies and investors today are facing increased scrutiny on these ESG issues. And even the conferences that are happening, you'll find in one way or the other, there will be a sub-theme somewhere, and it's touching these particular aspects on environment, on social and governance. Increased third-party funding. International arbitration, truthfully, friends, is not cheap. It is not at all. No wonder that quote that we began with, that arbitration between the lion and the lamb, you'll find in the morning that the lamb will be in the belly of the lion. It's not cheap. So the kind of parties that are going for this international arbitration and the kind of parties that are sometimes involved, there are some challenges when it comes to funding. I have quite a number of examples, and I think even my colleagues here online, where a client had to make a decision: do we proceed with the arbitration? That is the clause in our agreement. But when you count the cost for a client or for the other party, it ends up being very expensive. So if it's a dispute that cannot be resolved otherwise by amicable resolution, then it has introduced this aspect of third-party funding where external investors finance the arbitration of cases, and this is continuing to expand. In terms of trends, the fourth key trend that we came across is the greater emphasis on ensuring that arbitrators are free from conflicts of interest and biases, and this is the scrutiny of the arbitrator impartiality. You know, the award of the arbitrator is binding. So there is need at the doorway to ensure that as arbitrators are being selected, as they are being appointed, there are full proper disclosures and you've done proper due diligence on the arbitrators to whom you're voluntarily or to whom you're submitting your dispute, to adjudicate over the same. Then enforcement challenges. Yes, we know that the treaty framework, like we said earlier, avails the advantage of enforceability of arbitral awards in different jurisdictions. But when it comes to enforcement, there is sometimes a challenge where you get to enforce an international arbitral award in a jurisdiction, and there is some resistance of enforcement of that foreign arbitral award, where certain, of course, the grounds of resisting the award and a local jurisdiction or a court not recognizing that enforcement are set out in conventions such as the New York Convention. But you need to have careful legal expertise when it comes to enforcement in the local jurisdictions. And that is something that a trend that you want to keep abreast with. Now, regional trends, this one caught my eye so much because it brings us within our context of the East African community and where the different members of the East African Law Society are hailing from, but also exposing or opening our minds to the other different regional trends. Where you're having the growth of institutional arbitration hubs, I was quite interested to know what is happening, and as we follow the trends in the different EAC states. But right from the East African Court of Justice, arbitration is taking shape in a way that you have an institution there, the ESCJ Arbitration Institution in Arusha. Now you have, as one of my colleagues will be presenting earlier, the Kigali International Arbitration Center, which actually is really taking good shape. The Nairobi Center for International Arbitration. Back here in Kampala, you have the International Center for Arbitration and Mediation in Kampala, which came to supplement the CADA back home here in Kampala. In Tanzania, you have the Tanzania Institute of Arbitrators. All these regional and all these domestic institutions and hubs are intended to further a space where international arbitration can be undertaken. The Burundi Center for Arbitration and Mediation in Burundi. You have the South Sudan Chamber of Commerce, Industry and Agriculture in Juba. The National Center, even in the DRC, you have the National Center for Arbitration, Conciliation and Mediation in Kinshasa. So these are in addition to already the big established international arbitration centers, such as the ICC, the London Center for International Arbitration, Permanent Court of Arbitration, the SCC, the SCI, the SCAI, the SCDR, and all these in Singapore, the WIPO, in Hong Kong. You already have everyone, everywhere across the globe saying we are creating a space for international arbitration to happen within our jurisdiction. And yet, like we were saying earlier, and as Eunice was introducing us to this discussion, the parties that are involved sometimes in the international arbitration, you're dealing with parties from different jurisdictions, and later the enforcement is happening elsewhere. Then to close on really the trends, when you still look at the regional trends, the rise of the investor-state disputes, particularly around energy and natural resources, is trending because you have investors investing in as Africa is developing, as Africa is growing, as exploitation of energy and natural resources is growing. The disputes also for people who are interested and who are practicing in this area, that is something we want to keep watch of. Then the demand for arbitrators with expertise in local laws and culture in emerging markets. So you have investors come, and when they come, sometimes they come with their lawyers from, or their legal advisors from the country of domicile. But you need local counsel who understands the local laws and culture in that particular emerging market that this investor is exploring to invest in. So international arbitration, in terms of the trends, is evolving to meet the needs of a rapidly changing global business environment. We are talking of business, that's why we're talking of international commercial trade, and leveraging technology. That's why you can't afford to be left behind when technology is advancing, and addressing the emerging issues and adapting to regional dynamics. You have trade happening everywhere, and you have regional trade taking shape in the way the world is organizing their business relationships. Africa, here, of course, we are talking about the African Continental Free Trade Area, in addition to what we regionally have as the ESC and the different trading blocks across Africa, not to mention across the world, even in Europe and America and Asia and so on and so forth. So, friends, with all these trends, what are the implications for legal practice? What are we looking at? In terms of implications, of course, we are seeing increased complexity in international arbitration cases. When you read the old cases, if you pick off some cases and awards before the Permanent Court of Arbitration, and what you're seeing today, there are a bit of complicated or complex cases that are rising. And what does that mean? What is the implication? As a legal practitioner, as an advisor, as an arbitrator, you need an interdisciplinary approach and a multi-jurisdiction expertise from different places as a legal professional. You need to understand the commercial and technical aspects of a dispute, but also be well-versed with the laws and regulations of different jurisdictions. And then, of course, the language and cultural proficiency. You are dealing with clients, representing clients who probably do not speak the language in which you practice in your ordinary courts or in which you're instructed when you are undertaking your training. So the language and cultural proficiency has become a key implication to enable you communicate effectively as parties because you have parties with diverse backgrounds that are involved in international arbitration. Adapting to the use of technology, you know, we must get comfortable with the technological advancements. If you resist change, change overtakes you. The addressing of the rise of third-party funding in most of our jurisdictions back here in East Africa, when it comes to funding of disputes, there are usually ethical considerations that arise. But because we are talking about a specialized kind of practice, we are talking about a specialized mode of resolution of disputes, you realize that if you find yourself and you're advising a client, whichever side of the aisle that you are, you're looking at doing due diligence on the funders, assessing the risks, navigating those ethical considerations, and then ultimately negotiating the agreements, the third-party funding agreements. The increasing role of international arbitration in development of business law. You know, business law is about the practices, customs, and norms that business persons adopt. Innovation, usually the law follows innovation as people, as entrepreneurs, are taking risks, innovating how business should work post-COVID, and now with the AI coming, rather AI here with us, technology like blockchain, sometimes you find that our local practice, our business practice locally, our dispute resolution practice is influenced by these norms and practices that are developed from the global stage. So we also need to think about, as an implication, the need for developing a diverse skill set as legal practitioners. You need to have an interdisciplinary set of knowledge. You're not looking and focusing at one thing alone, because you'll have a dispute that will require you, at least at the bare minimum, to have some understanding of an interdisciplinary approach to things. Then a multi-jurisdictional expertise. You are in Kenya, you're in Uganda, you're in Tanzania, you're in South Sudan, you're in Burundi, you're in Rwanda, you're in DRC, to use the ESC context. You want to know, if you're dealing with a dispute, what is in the other ESC jurisdictions, not to mention across the world. So here you're looking at following platforms like the practice guides of chambers and partners, and the different publications, the different webinars, the different conferences that are happening. They expose you to this kind of multidisciplinary approach, and also growing your expertise in multi-jurisdictional matters. Then the technological proficiency. You know, you appear online and you're making a presentation, you're arguing a case. You need to be on top of your game as a practitioner. Then understand the commercial and ethical implications of the evolving practices in the field. It is arbitration, it has its nuances, and you need to be able to demonstrate that as a practitioner, you're on top of your game. I believe that that will help us spark a further discussion. But thank you, Eunice, for my time. That has been my quick run through on the trends and the implications. And please, I hand this over to you. Thank you so much.
Thank Thank you very much, Mr. Laston. That was a wonderful presentation, well put out, fantastic slides. And I think what we need to pick from what you've said is that, in summary, we embrace international arbitration because, just like democracy, there is absolutely no better alternative found yet to deal with cross-border disputes. It appears that in spite of some of its negatives, which may be there is no alternative to the neutral playing field that international arbitration provides to businesses. So thank you very much. You have given us enough to chew, to reflect upon, and hopefully to engage. Feel free to send your questions through the question and answer portal. Thank you very much. And right now, allow me to welcome once again Françoise to take us through effective institutions. Françoise from KIAC. Thank you.
Thank you so much, Eunice. Good afternoon, everyone. My pleasure to be speaking on arbitration as one of the young arbitrators in East Africa. And also, I give thanks to my colleague, Gaston, for the wonderful presentation. So my subject, I'll be talking about the effectiveness of arbitration institutions in East Africa. So as you may know, now that the business is booming in East Africa, having efficient arbitration institutions, they play a very, very big role in terms of providing effective dispute resolution mechanisms to businesses, to companies, to investors. And three or four aims of the arbitration institutions is to provide dispute resolution services through mediation, adjudication, arbitration, also to appoint arbitrators to manage or to administer the arbitration cases, to provide capacity building initiatives by giving out trainings, workshops, webinars like these ones, and also lastly, to promote their respective countries as one of the safest venue for international arbitration. So I'll be talking about the existing some of the existing arbitration institutions existing in East Africa. Also, I'll go through what it takes for an arbitration institution to be effective, so the challenges existing, and also the way forward. So starting with some of the existing arbitration institutions in Africa, I'll start with Burundi, which has the Burundi Center for Arbitration and Mediation, and the center was established in 2007. And the second one, Djibouti, they have what they call Intergovernmental Authority on Development Business Arbitration Center. But this authority has the members which are also include Kenya, Uganda, Eritrea, South Sudan, Ethiopia, Djibouti, Somalia, and others. So another one is Kenya. Kenya has the Nairobi Center for International Arbitration, which is actually one of the best arbitration centers in East Africa. It was established in 2013, and it has been doing well because since its operation in 2013, they've been able to administer more than 75 cases, which is a very good milestone because it's not easy for a new center to have even one case in a time of 3 to 5 years. So the next one is Rwanda, Kigali International Arbitration Center, where the center has started its operation in 2012, and for now it has been able to register more than 240 cases, and it continues to strive in the arbitration market. This is also a very big milestone because it has cases, around 40% of the cases are international cases from almost every continent of the world. And the center was also ranked the third in 2020 as the best African arbitration institution. It was ranked by the School of Oriental and African Studies in London, and this is a very, very good place compared to how many arbitration institutions that exist, because we have more than 90 arbitration centers in Africa. So being in the top 3 is also a very good achievement. And we also have the South Sudan National Chamber of Commerce, Industry and Agriculture. We have also the Tanzania International Arbitration Center. I try to find institutional arbitrations, not institutions that deal with arbitration, because there is a difference. Because when you are an arbitration institution, you have your own rules, procedures, and when you do arbitration, you may be using other people's rules, other institutions' rules. So in Uganda as well, we have International Center for Arbitration and Mediation in Kampala, which is an appointing authority, and it was established in 2019. So all of these, Uganda, Kenya, Rwanda, they are signatories of the 1958 New York Convention on the recognition and enforcement of arbitral awards. So to know how an arbitral institution is effective, there are some of the key points that are clear rules and procedures. First one, you have to have a transparent rules and procedures to guide the center. When you have clear rules, when you have procedures, it's one of the key factors for an arbitral institution to be effective. Those rules include initiation of arbitration, appointing arbitrators, rendering awards, conducting hearings. Some of the rules also have the cost and fees structure. So the second one is expertise and impartiality. When we talk about expertise and impartiality, we are talking about the appointed arbitrators. Who are the appointed arbitrators? Who are those people that you are trusting to give to your clients? So the arbitrators have to be impartial. They have, to have an international standard. They have to have the expertise that the client is looking for. Also, it's a lot of things when a client is looking for an arbitrator. So you have to have a pool of arbitrators that are trusted by the clients, so that it will be easy for the center to appoint. Also, for a center to be effective, it provides administrative support. Administrative support means, it manages the communication, it prepares or schedule hearings, it handles logistical arrangements, all the administrative works, a case that has arbitral institutions, they are the ones to deal with it. Also, the third key point is enforceability of the awards. As I mentioned earlier, for an arbitral institution to be well known or to be effective is that it has to be in a country where the country is a signatory of different conventions, including the 1958 New York Convention on Enforcement and Recognition of Arbitral Awards. So also, cost and the time efficiency is crucial for an arbitration institution to be effective. So it has to be, there has to be a clear fee structure. It has to have efficient case management for the clients or for the parties to be able to afford the fees, and also have an efficient case handled. Also, the flexibility for an arbitral institution to be in a very good position while having those clear rules. It's very important for an arbitral institution to be flexible in terms of its rules, but in terms also on how the case is. So, you may appoint arbitrators, you may have this language, you may have the seat, but when there's no flexibility in a case, parties may be uncomfortable. By flexibility, I don't mean that you have to breach the law, but at least have some flexibility to accommodate the uniqueness of the cases, because every case is different and they require different perspectives depending on its complexity. Another one is the infrastructure and the accessibility. As KIAC, for example, and also I think Nairobi has good equipment and infrastructure that allow parties to attend hearings either physically or even virtually. Also, even TIAC for Tanzania, they also have some, virtual spaces to accommodate local and international parties, because having a very conducive environment also help in terms of efficient and the speed of the case. But also, I cannot forget the promotion of arbitration. When I say promotion of arbitration, of course, the institutional arbitrations have to promote their institutions, but also they have to have, the support of government in terms of marketing, because sometimes, actually, almost every investor go through the government to be able to access the country to invest their, to invest in the country. So it's always good to have the government support in that side to help the arbitral institutions market themselves and be able to have those cases when it comes to handle the matter. So those are the key points for an arbitral institutions to be effective. But when we look at what we have in East Africa, we can ask ourselves, do we really have 100% of what I've just mentioned, or it's an ongoing procedure? Well, I would say it's an ongoing procedure, but again, looking at where we started when we didn't even have, for example, Rwanda, when you didn't even have an arbitration law, an institution which deals with arbitration, it's at least there is a milestone to be proud of, but it's an ongoing procedure to be able to compete on international level. So some of the challenges that we have in for arbitral institutions to be more effective, there is a trust in, there's a lack of trust in users, even as practitioners, because sometimes maybe at KIAC we always deal with trust, because some of the clients come, they say, I understand you have the rules, I understand you have the facilities, I understand the enforcement will be easy, but how can I trust you? How do I know that, you know, the arbitrators are not going to be you know, are not going to be maybe corrupt? Or how do I know that, you know, your award is efficient, is clear? It's just a trust, because every center, even the ones that are international, they could not have been there if the trust was not there. So it starts with us to trust our own system, because, for example, we've had at KIAC 240 cases, from which we have more than 130 awards, and we only have 2 awards that have been set aside. So you can easily understand how the KIAC, if the KIAC efficiency, you can easily understand it, because we give trainings to judges, we give trainings to, you know, everyone involved in arbitration, and that means that they know how arbitration is conducted. So for us to have just 2 awards being set aside out of 130 awards provided, it's also something to be proud of. So another challenge is that some of the arbitral institutions lack marketing and awareness, because you know, you may attend a training, you may attend a conference, but sometimes when you talk to someone, sometimes people from the West or others, when you tell them that we have, you know, capable arbitral institutions, some of them, they doubt. So they doubt because maybe we don't publish our achievements, we don't market ourselves, awareness is still, you know, at a lower stage. So it will be better if we did better by marketing and also provide awareness that we exist. We also do what other institutional arbitration that do all over the world. So what are the way forward? So after seeing the some of the existing institutional arbitration, after seeing what it takes to be an effective arbitral institution, and also the challenges. So the way forward, some of the way forwards would be, first of all, the governments should start supporting, or if they do it, they should emphasize on supporting the existing arbitral institutions, as I just mentioned above, by, you know, marketing it, by saying that, you know, you are an investor, we have this arbitral institution. You don't have to go outside East Africa, you don't have to go outside Africa, because the justice we provide is the same as the justice that is provided elsewhere. Another thing is, if we start to train, especially if we started to train from an early age, I mean by starting to educate young students in university about arbitration, it will create, you know, an arbitration environment where everyone that go maybe work somewhere, or if they finish school, they know something, they have something about alternative dispute resolution. Because in Rwanda now we've started that, where in universities we provide lectures on arbitration. So it gives a good picture because you can see that students are eager to learn about arbitration, because some of us who maybe went to university before, we were just having a sense of, law equals to litigation. So having an arbitration added was a surprise to some of us when we finished school, because we had that idea that litigation is always the way to go. So if we started at early age, it will be very, very good. Also, for the young arbitrators, if they could, be active by attending some hearings, being tribunal secretaries, as Eunice mentioned, when you are a tribunal secretary, you understand how arbitration proceedings are conducted, because you are in charge of scheduling, coordinating hearings, doing research, preparing, and disseminating the correspondences, and also preparing and review of every document that is being produced in that whole arbitration proceeding. So it's a very good thing if we started earlier. It will give us more efficiency as arbitration institutions. So also to put also having case management software, because in Rwanda in litigation we have a software, but it would be also good if we had softwares in arbitration that manages cases, because as Laston mentioned about technology, as the world is evolving and go to technology, it's always good to have a software. Like if you market your institution, you have to have what to tell to those people that you're marketing to. For example, at KIAC, we have a case management software that is almost done. So it will help us in efficiently manage cases, and also giving reports. So also using institutional arbitration, which is the last way forward, is preferring institutional arbitration over ad hoc arbitration is a very good way to go, I would say. Not because I work in an arbitration institution, but when you work with the institutional arbitration, there is statistics. There are some of the statistics that are there, that will help people understand how institutional arbitration, or how even arbitration in general is doing in East Africa, or in Africa, or even in the world. So from the research, there are 80% of cases are managed by centers, but there is still between 10 and 15 cases that are being managed in ad hoc, and we will never know how the cases ended. So choosing arbitration institutions is the way to go, because it helps in capturing what's going on in arbitration, but also gives peace of mind to either arbitrators and also the parties. Thank you so much. That was what I had today. Looking forward to so many discussions. Thank you.
Okay, thank you very much, Francoise. Thank you and congratulations to KIAC for the steps that are taken to be recognized for the work it's doing. For your information, in Kenya, we have been having a dispute between a group called Gen Z and the government. And this dispute is likely to have far-reaching implications in terms of choice of seat and venue for international arbitrations involving the government, because as been the experience in many African nations, we are coming from a place where many of our documents always chose London Court of Arbitration, ICC in Paris, and Switzerland as seats and venues. But now, I think in Kenya, now that we have austerity measures, I don't know about other countries, we are likely, hopefully, to see more use of Kigali Center to resolve international arbitrations and Nairobi, because you have rightly told us that the justice provided in London is the same justice provided at KIAC in Kigali, and the same justice provided in Nairobi at the Nairobi Center and our various local institutions, and you've given us the difference that makes one effective and the other not effective. So please keep your questions coming. Thank you for that presentation. Allow me to invite Colin. Please, Colin, take the floor.
You see me?
And take us through the all-important discussion of opportunities. Welcome.
Yes. Thank you very much. Can you hear me?
Yes, loud and clear, we can hear you.
Okay, perfect. So I will get started. Like that earlier introduced me, my name is Colin Gatete. I'm an advocate in Rwanda. I'm the practitioner and the lecturer. I can see some of my students and former students attending here. I had invited them, so I'm glad you're all here. And especially, I think it concerns not just the existing practitioners, my part, because I'm supposed to be discussing about opportunities in international arbitration for legal practitioners. So I think it is just not only important for us who are already practitioners, but also for aspiring practitioners. So those who are still in university, those who are in law school, those who are, who have graduated all those stages, but still thinking about where to head. So this is an important topic, and I'm glad you have been selected to discuss about this. So, like they mentioned, my part of the discussion will be about the opportunities in international arbitration for legal practitioners. So, before as we proceed, I think maybe the first thing one would wonder or ask themselves is, breaking down that theme or what I'm supposed to, and then we shall look at who are the practitioners, and then lastly we shall look at the opportunities and where are they coming from, where these opportunities coming from. We'll look at that in my presentation. Now, what is international arbitration? First, there is no specific definition of international arbitration. There is no authority that is applicable for all jurisdictions. And this is simply as any other international field of law. There is no specific definition. However, we borrow definitions from different sources. And in my case, I will be borrowing from two main renowned international arbitration instruments, particularly the New York Convention, and more importantly, the Unicitral Model Law by the UN, the UN Model Law on international arbitration. So now, if you look at the definition, what makes arbitration international, or what is international arbitration? Because the presenters before me had explained what arbitration is, and I think one of the members also explained a bit about it. So I'll just touch a few things that make it international. One is the place of business. So in other words, where the parties are from different states. That is one. Then where the place of arbitration. Now, place, seat, these are technicalities that I don't think we'll have time to get into, but those of you who are here, or those of you who will want to know, this is something you can later get into, place and seat. But the place of arbitration is in a foreign jurisdiction. The place of performance of the contract performance is in a foreign jurisdiction. Where the subject matter is or closely connected is in a foreign jurisdiction. These are items that make arbitration international. And this kind of definition, you look at it from if you look at the unilateral model law in the Article 12, it provides for what makes arbitration international. So now, having understood what this international arbitration is about, as a result, one would want to understand what is the importance in the first place. And I think one of the members had mentioned why it is important to have. So there is importances of arbitration. And now what I will focus more on is importances of international arbitration. So ordinarily, as you may know, one of some of the components of the descriptive features of arbitration, just arbitration, include, for example, neutrality. So whereby impartial platform of resolving disputes, and impartial, very impartial in the sense that you choose the judges, the arbitrators. Now, what makes arbitration, particularly international arbitration, more important is that the neutrality is even more, so to speak, than ordinary arbitration, in the sense that the neutrality or the arbitrators that are going to be appointed and the locations and like I mentioned, the definition happen in different jurisdictions, which make it more neutral than it would have been had it been in an arbitration, and particularly a local arbitration. That is one. Then two, about enforcement. Now, enforcement ordinarily, of course, there is, like I said, there is ordinary local arbitration, but the enforcement of these ordinary local arbitrations tend to have challenges, tend to be set aside. I think Francois mentioned something about having institutions. I'll also get to that. But most of these international arbitration, in as much as they are institutional, even the ad hoc ones, when they are ad hoc international arbitration matters, the enforceability tends to be much higher than it would have been had it been a local international a local arbitration that has been handled locally. So enforceability, then things to do with efficiency. Efficiency, in addition to the I've seen with this efficiency, why I'm saying it is the international one is more efficient even than the local one, is because I've seen because of conflicting schedules of different parties in different from different jurisdictions, they tend to be more they tend to give in a little bit more and let the other party, so they tend to forego a lot of their local practices, and therefore making it more efficient than it would have been had it been all local arbitrators. Then things to do with the expertise. Again, some of these jurisdictions, especially in our part of the world, sub-Saharan Africa and other developing countries, there's an issue with expertise. Some of the presenters before had mentioned that you get the opportunity to have experts in these specific sectors. So, for example, if you're doing a dispute between banks or international lenders and local lenders, this kind of expertise in some of our jurisdictions is not easily available. And so only with international arbitration, you can easily get this kind of expertise, and therefore ultimately making justice served in international arbitration much more solid, so to speak. Now, then let's see the second, the other part that I will be discussing is about the opportunities. The opportunities, no, sorry, before I get to the opportunities, let's first look at who are the practitioners. Who are the practitioners in international arbitration? So that especially those who are aspiring to be practitioners can easily find where they fit. First, there is counsel. Counsel, there's room for international international presence in terms of being a foreigner and acting on behalf of your client. Now, this tends to have some issues in some jurisdiction in terms of who can represent who in a specific, especially where depending on where the seat or the place is, there's some challenges there. But the beauty about it is that you are able to represent, especially countries where they have really promoted proper international arbitration. They tend to allow counsels, even from foreign jurisdiction, to come and submit on behalf of their clients, even when they're coming from other countries. So, in fact, this is something that also the other international arbitration centers should be doing in their home countries, including ours, to advocate for if especially where the bar associations are not allowing foreign practitioners to come and practice on their land. This is something that has to be addressed. It's something that will be addressed as we grow. But it is an opportunity to have these councils. So basically, councils have the opportunity to represent their clients even out of their countries that they are coming from, to do their submissions, orals and written and so on. That is one. Then two is about the arbitrators themselves, the judges, the decision makers. Sorry to call them judges, but just for convenience. So the arbitrators, there is opportunity in the sense that, especially now with this international body like the chartered, the CIAB, the Chartered Arbitrators, which is pretty much internationally recognized. You tend to have standardized practices whereby you have arbitrators coming from different parts of the world and be admitted to the lawfully allowed practitioners in other jurisdictions. And Rwanda, I think, has been doing this very well. I have personally been involved in matters where we've had international, let me not, I can call them international or non-Rwandan or non-Rwandan, not even East African, non-Rwandan, non-East African arbitrators. So this is just an indicator of how it's an opportunity for arbitrators to practice in their home country and beyond their home country. Then about the other practitioners in the international arbitration space include, for example, people like experts. Now, experts, like I said, this is international arbitration is where you get people from diverse backgrounds coming together in one room to resolve these disputes. And so if you're coming from different backgrounds, chances are you will know you'll be connected with people from other or your home jurisdiction or other jurisdictions where you have more advanced or more knowledgeable people in certain spaces or specific technical, legal, and industry-related issues to help give justice at the end of the day. So in other words, the experts here have also been, is an opportunity. This is something that also gives opportunity to for them in international arbitration. Then there are others such as advisors. Usually these will be like in-house counsels, or even other consultants who are hired to advise, especially these institutions when it comes to drafting arbitration clauses, or negotiating these arbitration clauses, or negotiating or being advised, or even being advised on procedural arbitration procedures. So these advisors also have this opportunity for them because given the kind of multinational, the global village that the world has become today. Then lastly, I will talk about the institutions themselves. Francois from the Kigali International Center, Arbitration Center, mentioned about how many cases they've been handling, and how many, and how it has been open for the international community to come to Rwanda to resolve their matters here. And so this is also an opportunity for the institutions themselves. So I'm just talking about Kigali International Center as an example, because I think they've done pretty well in the region, but also we know the other older one, the other renowned arbitration centers. For example, the ICC in France, and also the Dubai International Arbitration Center coming up very fast. And then also the older ones, the LCIA, the London Court of Arbitration, and so on. So all these institutions, there is opportunity for them also because they are being able to resolve. So in other words, you get KIAC resolving matters from a Kenyan versus a Tanzanian, or versus a Nigerian, or versus some American or Australian. So these also the institutions themselves have been also there's opportunity for these for them in this international arbitration space. Now, one would wonder what are the skills required for these people to exist in the same space of international arbitration. And I can break them into three main ones, but one is a strong international understanding of international law, and particularly commercial and investment practices. So where we have international entities coming together in one room to have their matter resolved, of course, there must be very, very strong understanding of international law, international, maritime law, trade law, conventions and so on, treaties and so on, clear understanding of these laws, and then, of course, commercial practices of this specific space. So that is one, a strong understanding. Then two, proficiency in languages. Proficiency in languages. Now, if you go to some of these jurisdictions, if you look at the Cairo one, or even the Dubai one, in most of the people going there are mostly Arab-speaking practitioners or clients or parties. They're the ones going there. And why? Because they think, or they find more people there with proficiency in the language they are most conversant with. It could be a choice of language as stipulated in the arbitration clause, because even the language, as you may know, even language is a point of is an item that can be decided by the parties. The parties will say, we are going to have Arabic language or English language or Chinese, whatever. The fact that they've decided, that means it creates room again for these international practitioners who have the language proficiency that is necessary at the time. And also, of course, cultural sensitivity, Cultural sensitivity in the sense that, like I just mentioned, some of these matters are largely, by driven by institutions which come from certain, or which have a stronghold in certain jurisdictions. And so sensitivity of the differences in culture is very important. I have been in arbitration matters, international arbitration matters, where issues of cultural sensitivity have been a bit, you could see it could at some point be a point of tension sometimes, but also it's an opportunity again. If you're able to develop the skill of sensitivity to other people's cultures, respect, then surely you're going to have one of the key required skills for a practitioner in international arbitration. Then lastly is ordinary negotiation and the advocacy skills, but those are the main ones. Now, so having looked at the people, the practitioners, the people involved, looked at what the skills they should possess, then we look at why. What are the opportunities? What are the opportunities in international arbitration? First, I think everyone on the panel and will agree with me, anyone who has had some international arbitration matters, the value is high. The value is high value disputes. And as practitioners, most of us enjoy high value disputes because, of course, it means the compensation for the work done will increase. So it is a lucrative opportunity for practitioners. It will be lucrative for everyone involved, actually. The lawyers themselves, the experts, the institution, everyone involved that will be involved in this matter. The higher the value, the more lucrative and attractive it will be. So that is one opportunity that you cannot, I began with that one, but there's many others, of course. Then second is about expanding professional reach and expertise. Expanding professional reach. Remember, when we are talking about arbitration, particularly international arbitration, or arbitration in general, we are looking at it as one of the items of ADR. ADR. So ADR versus litigation. So we have ADR versus litigation. So if you look at the room available in international arbitration for ability to resolve cross-border disputes is enormous, compared, of course, to litigation, which tends to be very territorial, it tends to be very local, and so cross-border practice becomes a problem. But with the international arbitration, that's one of the opportunities that has been there. Cross-border dispute resolution or cross-border practice has been an opportunity for practitioners. Then the other thing is about the specialization that comes with it. Specialization, especially in niche areas. So, like I just mentioned, the more you're dealing with these kind of matters, the more you have an opportunity to learn more, be exposed more to the more specialized niche areas. So this is something you can get in international arbitration, and then of course the other thing is international exposure, no brainer. So if you're doing international arbitration, is where you'll be able to meet people like Eunice, people like Francoise, people like Laston, Ida, and so on. All you meet several people from different backgrounds, and therefore creating and giving you an opportunity to be exposed internationally. And not just that, it also gives you an opportunity to be, in terms of, work, in terms of working for these international centers. Some of the international centers, like if you look at Paris, the ICC, if you look at the ICC, and the ICD, the ICDI, and the LICA, the London Arbitration Center, the World Bank one, and these other ones. If you look at the people working there, they tend to be not local. So if you go to ICC, there's a significant number of non-French people. So this is the kind of opportunities that are there. So for professional growth, for working for this kind of international renowned bodies, prestigious bodies, and not just not just institutions, but also even other opportunities such as law firms. So we have international law firms which are doing many, which have presence in many countries. And I have my good friends in you find in London or in Paris, and they're from Cameroon, they're from Nigeria, they're from Kenya. I have those who are in New York, and they're from Kenya. And they're doing all these sorts of things. So all of these are opportunities that come with the international arbitration. So this is under professional growth. Now, I will continue to discuss about going forward. Going forward, we must agree. Going forward in terms of opportunity again, we must agree that the demand is growing by the day. The more businesses are doing cross-border businesses, international transactions, the more that is happening, the more the demand for international arbitration increases. No brainer about that. So, which means there's going to be a demand for skilled arbitration practitioners, and more importantly, practitioners as a whole. So there's going to be a growing demand in the international space. Two, there's going to be opportunities to involve in a high-profile matters. Like I said in the beginning, most of these international arbitration matters, they're not usually small value disputes. On average, they're not small value. I've not seen any myself. The one that was a bit small that I saw, the client was trying to achieve something beyond the value that they were trying to prove something else. And, that's when we did the small value. But otherwise, there's opportunity to involve in high international high value cases. That's second. Third, in international arbitration, there's opportunities for collaboration, networking. So, like I think it's Eunice who mentioned before, there's conferences, there is forums, there is training programs, and so on, and forums like these ones, where there's a lot of opportunity to network. So remember, for example, some of these arbitration centers, so not arbitration centers, arbitration clauses, sometimes they have provisions that stipulate where the nationality, where these arbitrators are supposed to be coming from. So if they are asking me that one of the arbitrators is supposed to be coming from, say, Uganda, it will be easier for me to easily refer or to recommend or to appoint, Laston, for example. because of these opportunities, because of this kind of forums of networking and collaboration that international arbitration has provided us. Then lastly is about development of expertise. There's going to be a lot more expertise, specialization. This I've discussed. So all of these are opportunities that are coming in the future. Now, how do we exploit? Eunice, you want to say something?
Not yet, but I'm listening.
But it has.
Okay. Gabriel, you're saying something? Okay, I think they're not. I'll just proceed. So now let's get into the phase of looking at how do the legal practitioners, how can they exploit these available opportunities and the ones that we can see that are coming in the future in the space of international arbitration. First, education, training. Knowledge is key for this. There is fortunately, there's been opportunities for training. There's been even in our own Rwanda here, we have now the CIAB, we have a branch, and one of the things that we're trying to build is to have more people with capacity to even train others. So first training, and then those who have more from especially those who have more understanding on this field of practice. So training and education, knowing, growing in your understanding in this space is one way to exploit the available opportunity. That's one. Two, gaining experience, practical experience. Now, I think it is Francois who mentioned something about a small way of gaining this experience. One is just simply by being a secretary of a panel. Being a secretary, you will follow whatever is going on there, because remember, arbitration in its nature is more it is in closed doors. And because it is in closed doors, it's not like Courtwell just walk in and just just go and start listening. So the only way is to start doing some of this kind of work, such as providing support roles slowly to this council, to the arbitrators, to the institution like KIAC and Nairobi International Arbitration Center and others, providing that kind of support role is a way to gain this practical experience, which will enable you in the future to be either the roles we mentioned before, counsel, experts, employees of the institutions, different arbitration institutions, and so on. So this experience is this is one way to exploit the opportunities. Then third is networking. Again, networking. For sure, like I mentioned earlier, if I'm going to choose someone coming from to be an arbitrator, chances are I'm going to choose someone I know. I just don't get people from anywhere. So and one of the forums for knowing people is forums like this one and others where we meet in person. So networking is very key. Attending conferences, professional organizations, and like this one, East African Society and the Chartered Arbitrators and so on. It's an opportunity to get to be people to know that you are there, what you're doing. And then opportunities come through people. The people are the ones who make these things work. Then also other ways to explore these opportunities is doing research and then by doing research, you're able to do publishing books, talks, and so on. Again, this is also an opportunity. Is a method or a way in which you can exploit. And then we cannot ignore technology. Technology has been very instrumental in our day-to-day doing of our affairs. You can imagine I'm now in Kigali, Eunice is probably Nairobi, Francoise is probably somewhere else, we're in Bujumbura, and we are talking and we're doing, we are exchanging experiences. So we cannot ignore to leverage technology. So leveraging technology is the fifth item that we practitioners can exploit. So by doing that, you're able to do research, you're able to attend meetings like this one, and then even when you're inside as a practitioner, you can be able to do, for example, hearings. I have had international arbitration matters where we didn't meet. I've never met them in person. Well, I met them after in conferences, but before that, I'd never met these fellows, the arbitrators, the counsels of the other side, apart from our clients. So how did we achieve that? Technology. This is what we leveraged. So this is an instrument that we can also exploit to exploit the available opportunities in international arbitration. Then lastly
Colin.
is pro bono work.
Yes.
Yes.
Colin, if you can hear me, I'll just request that, I'm seeing the time has really run out. If you can just maybe conclude so that we can give the participants some time to ask the question.
Yes.
Thank you.
I'm actually to the end. So I have explained how to the opportunities, how to exploit them. Now I'm going to talk briefly. I want in maybe 1 minute is the beauty that has been there with harmonization of the arbitration laws. So, well, harmonization has been there since, like 1959, when the New York Convention was on enforcement of arbitration award was, being ratified and adopted by many other countries. Then there is the Unicitral Model Law, which was there in since '85, and also recently, in 2000, mid-2000, amended. And then we have other conventions like the SID, which does more of a interstate arbitration matter. All these legal instruments are being used as a harmonizer. They're harmonizing different arbitration regimes in different countries to be kind of similar, and they've really done a good job, especially the model law. They've done a good job, especially for developing countries. So by doing this, we have kind of standardized principles, standardized procedures, standardized expectation, which makes opportunities and ability to work in international arbitration much easier. So thank you very much. I think I will stop there for now, and then maybe I'll give my, maybe at a later point, I'll add something later. Thank you so much.
Thank you for that engaging
Eunice,
discussion. It was difficult for me to come in because of the passion in which you have for the subject. Thank you, and thank you very much. Now we have time only for Ida, the woman leader from Burundi, to take us through and to carry on from where Collins was speaking about opportunities. She'll be taking us through specialist areas in which arbitration is expected to see development within the course of the year. So allow me to invite Ida to take over. Thank you. Hopefully we can have some question and answer session. I have seen Kenan Masai's hand has been up for quite a while. You can also just type your question. Thank you for answering a lot of the questions that have been online. Last on, I just wish to direct our participants to check on the questions online and how they've been answered. Thank you. And the rest of the panel, just look through the questions. You can add to them as well. Thank you. Yes, Ida, take over.
Okay, thank you so much, my sister, Ines. It's my pleasure to be part of this panel. So I'd like to apologize. I want to switch off my camera because my network is very low. So you have to apologize me. But after we go through to the question, as an arbitration is an alternative dispute resolution method. Arbitration in Africa is still lagging behind other regions of the world. However, over the last few years, Africa was been doing its best to catch up, notably through arbitration centers operating in particular geographical area or in specific field. But even if there are many changes, there is a need to develop this mode in other sectors where arbitration is still lacking. For example, is in integrating technology into arbitration. What is lacking in arbitration in Africa is very often the cost aspect. In fact, most people do not go to arbitration tribunals because they are unable or less inclined to pay the cost of arbitration. So international arbitration with virtual platform and tools will contribute to the efficiency and accessibility of dispute resolution. In particular, this will help to circumvent the financial aspects, exorbitant costs, which is often the main obstacle. Another area is the national arbitration law reform. Several important arbitration jurisdictions are expected to introduce reform to the national arbitration law. This will raise awareness of the need for internal, regional, and continental rating, and the fact that Africa has a lot of catching up to do in terms of referring and, above all, competent referring. The development of domestic arbitration will contribute to the development of international arbitration. This development will also help African arbitrators to acquire experience, which will help to make up for the underutilization of Africa arbitration practitioners in both investment and international commercial arbitration. And another area is the sport. Sport can also give rise to disputes that may require the intervention of arbitrators. Those disputes may cover contract aspects and disputes that may arise in this field. Like an other worker, an athlete has a contract with his or her club, sponsor, or federation whose commitment must be respected by both parties. Disputes may arise in particular if contractual clauses are not respected or if a difference of opinion arises between the parties concerned. A typical example is the Court of Arbitration of Sports, whose mission is to settle legal disputes arising in the field of sports. This tribunal is arbitral award which have the same executive force as judgments handed down by ordinary courts. The Court of Arbitration for Sport can also use mediation to find an amicable solution. The courts of arbitration can, for sports, has also the authority to rule on all disputes which a direct or indirect link to sports, such as a disciplinary disputes, grouping cases, or disputes with commercial aspects, sponsorship, as fast-growing industry on the African continent. Sport lacks a board capable of setting disputes with sport-related aspects. This will enable Africa to gain a certain degree of independence from courts of arbitration for sport, which is an international institution. Another area is with the continent's abundance of minor and rare material, multinationals are rushing to Africa. As we know, mining projects require long lead time and are often politically sensitive. As a result, the prospect for disputes is acute and they are often submitted to arbitration. So arbitration, the mining sector has increased considerably over the last few years. Metals and miners play an important role in foreign direct investments, and the need for complex contracts has attracted considerable attention for arbitration practitioners. The main area that may require arbitration, the mining sector, are commercial disputes, expropriation, and social concern. Foreign investors appreciate international arbitration because it gives an impression of neutrality, stability, and independence of all consideration of national policy. Hence, the need to set up competent arbitration centers for mining disputes is also needed. Another area is the intellectual property. The intellectual property has a clear capital importance as intertwines with many sectors, including the economy and international trade. Traditional IP disputes were mainly had by national courts. Indeed, IP rights were historically linked to public policy, which also conferred exclusive jurisdiction on national courts to settle IP disputes. The reality is that today, most jurisdictions recognize IP disputes as arbitrable. So arbitration has a number of intrinsical unique characteristics that make it more appropriate alternative for resolving IP disputes. Those include the speed and the efficiency of arbitration procedure, the flexibility and the use of the latest technology. We have another area which needs to be developed is we need to increase in life science arbitration. Recent data from major arbitration institutions suggest that the proportion of disputes in the life science sector being resolved in arbitration rather than through the courts is rising. The trend appears to reflect the innovative and dynamic nature of the industry, as well as the advantage that arbitration can provide life science companies in disputes, including, as I said, confidentiality, adaptability, and cross-border enforcement capability. Another area is the third-party funding. The use of the parts funding to pursue arbitration claims has become more widespread in the last 5 years, while monetization of awards when a finance provider advances capital to the award creditor in return for a portion or assignments of the award, is also a growing phenomenon. However, parties and founders must pay close to the varying rules and challenges regarding to the third-party funding in different countries to avoid the founding arrangement being rules enforceable by the regional national courts. Recent developments in England and in the Europe, Nigeria, and India illustrate the varied stage of market development and the unique challenge parties and founder may face in different jurisdictions. I think that most of some areas was the last panelists were talking about it, and I see that the time is over. I think that we'll get more time to discuss another time in order to give the opportunity to the participants to ask questions and to interact. Thank you so much.
Thank
Okay.
you so much, our woman leader in Burundi. I want to take this opportunity to just take note that our webinar ought to be over in the next 1 minute, but allow me to just acknowledge that the questions that were asked in the Q&A section have all been answered. So unless there is a burning question from the participants, allow me to open the floor for any one of you to ask the question. I wish to know whether Kenan Masai's hand is actually up by mistake or he wishes to ask a question in reality. Conrad Jabo says thank you. You're welcome, Conrad. If there is no question, allow me to go back to my panelists and ask each of them to make a parting shot, starting with Mr. Gulume from Uganda.
Yes, well, thank you so much, Eunice. My parting shot takes me back to where we started in that quote that don't enter into arbitration proceedings as a lamb when you are arbitrating with lions. I think all the panelists have done, my fellow panelists have done an exceptional job in trying to get us to understand the ins and outs, the institutions, the places, whom you need to talk to, the opportunities. And it's just the beginning of a very huge conversation. Yourself, Eunice, you have been in this field for quite a number of years. 2 hours are not sufficient to talk about everything there is on international arbitration. So it's just a conversation that has started. Let's keep going at it. Those will be my parting shots. Thank you so much. Eunice, you're muted. You need to unmute.
Sorry, thank you for that. I just wanted to say I've had a dispute between an investor from Uganda and a government entity, and I think as Francois was saying, the field is level playing field, and the justice is there in this region, and that was through KIAC. So I want to welcome her to give us her parting shot. I believe you're muted as well. If you could kindly unmute.
Sorry about that. I was actually thanking you for conducting this whole session. And I was saying that the word of today is that let's make arbitration institution and arbitration our own. It starts with us and then it extends to others. Thank you.
Advice taken. Could we hear from Mr. Collins Gatete?
Yes, yes. Thank you very much. I will also thank the East African Law Society, Mr. Gabriel Achaye, yourself for doing a good job. And what I can say is, like I mentioned, my topic was literally about the future. So we have, there's a lot of opportunity in this space. Maybe one piece of advice I can share is that how do you get in this space? Simply draft arbitration clauses and put them in your contract. And then that is the first step, among the first step or easy way to get into arbitration. When putting the arbitration clause as a dispute resolution clause in your client's contracts. And then it will be, you will be part of the opportunities that are going to be there in the future in the international arbitration space. Thank you very much. Have a pleasant afternoon.
Thank you. And I hope we can have another session just to look at what Collins is telling us about the arbitration clauses and how we can make them work for us in East Africa. Ida, kindly give us your parting shot.
Okay. I would like to thank to ELS for this opportunity, and to thank also my sister Eunice for the good moderation. And I hope that African country will develop the specialized areas in which arbitration is expected to see development within the course of this year on the areas which I was talking on. Thank you, Gabriel. Thank you, all panelists. Hope that we'll meet again. Have a good day.
Thank you very much, my sister from Burundi. Allow me, before I hand over the seat to ELS, to request for a moment of silence, because I don't know if some of you have known this or not, but in Kenya, we are mourning a great judicial mind, a jurist of outstanding stature, and an arbitrator as well. His name is Justice David Majanja, whom we lost yesterday. He's been very active. He's been a great mentor and tutor, and we all need mentors who are really great. So maybe just a moment of silence to our departed colleague. Thank you for that.
So rest in peace.
Thank you so much. Yeah. For those practitioners in Kenya in dire need of ADR trainings, where do we seek refuge? Marilyn Osebe, you can get in touch with me through the ELS or directly. My name is Eunice Lumalas. I'm also the chair of Women in ADR, so we can always find a way of directing you on where to get specialized training. The Chartered Institute of Arbitrators is available, Nairobi Center for International Arbitrations, as we had. These centers are now coming up in offering training as well. So I think your questions can also be directed to ELS Secretariat, which can share specific questions to the panelists whom you wish to have them address. Thank you so much. Is Gabriel around? I'd like him to take over. Thank you.
Thank you too.
Anyone from ELS? I think if Gabriel is not available at the moment, allow me to end the webinar. I wish you all a wonderful evening. Thank you. Wherever you are, keep at this. We'll make arbitration work for our region. Thank you so much, and all the best in whatever you're doing. Participants, thank you for your patience. Thank you.